past sexual experience not relevant to determine consent. This was recently observed in a slew of media articles when they reported that one additional sessions judge in New Delhi dismissed the anticipatory bail application of an accused person who was accused of raping a woman that he knew. The anticipatory bail application and the arguments put forth by the counsel for the accused were that the girl specifically came down from Pune to Delhi to meet him. She voluntarily went with him to the hotel where the alleged incident happened. The girl herself gave her government-issued identification to the hotel staff. Therefore, the facts around this situation established that this was a consensual sexual activity. The counsel for the accused also submitted that there were previous sexual encounters between the accused and the complainant as well, because of which this is a clear-cut case of false implication. On the other hand, the counsel for the complainant and the public prosecutor made a few submissions. Merely going to the room of the person is not enough to establish that there was consent. The girl gave her ID to the hotel staff thinking that this was a COVID protocol. The accused person booked the room without notifying the complainant, and therefore there was an ill intention on behalf of the accused person to commit rape upon the girl. He was the one who messaged her, told her to come and meet him. The accusations are clear and unambiguous that he fingered her and forced her to give him a blowjob, after which she went to the bathroom and vomited, and even there he forced himself sexually upon her. The other submission was that she gave in and she did not raise a hue and cry because she was afraid that he will hurt her if she does that. And there is also a text message by the accused person to the complainant in the later part of that day where he apologizes. So a message saying sorry by the accused to the complainant. Now the judge, while dismissing the anticipatory bail application, mentions two sections of the Evidence Act, that is section 53A and section 114A, 114A of the Evidence Act. Both of these sections were inserted in 2013 by the Criminal Law Amendment Act, which was passed when the gang rape of the Delhi gang rape incident had ignited fires all over the country. Section 53A of the Indian Evidence Act says that the character or previous sexual experiences of the complainant are not relevant. And section 114A of the Indian Evidence Act says that in an allegation of rape, if it is proved that sexual intercourse did take place, then if the girl says that the consent was not obtained, then it shall be presumed that consent was not obtained. Talking about these two sections, 53A is a very, very important section because earlier what used to happen often was that in a case of an allegation of rape, the prior sexual conduct of the victim would often be brought into question by defense counsels. And the defense counsel would say that you are a woman of such easy and immoral values that you would go and sleep with anyone. Perhaps the fact that you are a prostitute, which used to happen a lot in cases where a prostitute would allege rape. They would say you're a prostitute. How can you even say that there was no consent? This is your business. To deal away with this, 53A was brought in. And 114A also is a very, very important section where otherwise the criminal jurisprudence says that any accusation, the proof must be presented by the prosecution and must be convincing enough to be beyond reasonable doubt to secure a conviction of the accused person. However, especially in cases such as rape, where majority of the times the offense takes place behind closed doors, it is an effort on part of the legislature to ease the prosecution's burden of proving the guilt beyond reasonable doubt, and says that there will be a presumption, which I do not think is incorrect. I think this is a remedial measure which was needed. However, for the Sessions Court judge to invoke the provisions of the Evidence Act during the stage of hearing of anticipatory bail of an accused person is something which I feel is highly prejudicial and to a great extent incorrect. These are provisions of law which are to be exercised, which are to be considered by the trial court during the time of the trial, and more importantly, even if such deposition takes place, then at the conclusion of the trial to determine whether the person is innocent or guilty. These provisions are to be looked at very, very stringently. You have to follow the rule book. However, in an application for anticipatory bail where a person is apprehending arrest, for the court to say that if the lady says that there was no consent, we are going to believe that there is no consent, is perhaps something which requires a little more introspection. Of course, over the several past centuries, women have been attacked, women have been subjugated, women have been subjected to horrendous sexual violence. That does not mean that there are no cases of false allegations. I myself, being a defense counsel, on a very, very, very regular basis, see so many cases of false allegations of rape, sexual assault, molestation, outraging the modesty of a woman, words harming the decency of a woman. And in all these situations, I wonder to myself if after the person goes to jail, spends a couple of days, weeks, months, robbed of his liberty, and at the end of it, it turns out that the case was a bogus one, who compensates that person? To what extent can that person be compensated? And can things return to normal ever? However, having said all of this, I would remind you, the viewer, that I have on numerous occasions mentioned that sessions courts are usually very, very reserved in granting anticipatory bail in any kind of situation. This is another great illustration of the sessions court not granting bail, that is anticipatory bail, to an accused person. However, there are multiple rounds still left. There is the Honorable High Court of Delhi, a great court where very, very bold judges sit, who I have seen on most days do a fair amount of justice. If the Delhi High Court judge is not convinced, there is also the Honorable Supreme Court, which also is known from time to time to step in and actually do some decent justice. If again that does not happen, the person merely needs to surrender before the court, again move an application for regular bail, again before the sessions judge. In all probability, that will be dismissed as well if that happens. But then when you approach the High Court and the Supreme Court, after having spent a couple of days, weeks in jail, there is a very, very good chance that the person will be released on bail, especially after the recording of the testimony of the witness.